Hello and good day, attorney and everyone. I am hoping that you are all well and sound. Today, I will report a case involving issues about defective contracts, particularly the GR number 110053, dated October 16, 1995, with the Development Bank of the Philippines as the petitioner and the Court of Appeals, Celebrada Mangubat and Amner Mangubat as the respondents. Without further ado, let's begin. First, as for the facts, particularly the petitioner's or plaintiff's claims. On July 20, 1981, the Petitioner Development Bank of the Philippines performed a deed of absolute sale in courtesy of the respondent spouses, Celebrada and Abner Mangubat, for a parcel of unregistered land located in the province of Camarines Sur, having an area of approximately 55.5 hectares. After the respondent's appeal, DBP raised that the trial court incurred errors, which includes errors in declaring the deed of absolute sale executed between the parties cancelled and annulled on the ground that their independent appellant had no title over the property subject of the sale. As the case proceeds, DPP also claims that the trial court and the respondent court of appeals blundered in ordering the reimbursement of taxes and the cost of the relocation survey, there being no factual or legal basis, as the private respondents merely submitted a list of damages. Moving on with the respondents' defendants' claims, on October 14, 1980, the respondent spouses opt to buy the land of DBP for an amount of 18,599 pesos, by which was settled for 25,500 pesos. Later on, the respondent spouses applied for an industrial tree planting loan, with DBP requiring the former to submit a certification from the Bureau of Forest Development that the land is alienable and disposable. But the said office issued a certificate classifying the land as timberland or not subject to disposition, and nevertheless, the loan application of spouses was eventually permitted by DBP in the sum of 140,000 pesos. And despite the aforesaid certification of the Bureau, in which a substantial sum of 118,540 had been received by the private respondents, but on July 7, 1983, as plaintiffs, the respondent spouses filed a complaint against DBP in the trial court, seeking the annulment of the subject deed of absolute sale as DBP acted fraudulently and in bad faith by misrepresenting itself. To end the facts, the decisions of the lower courts. On May 25, 1990, the trial court rendered judgment annulling the subject deed of absolute sale and ordering DBP to return the 25,500 pesos purchase price plus interest to reimburse to respondent spouses the taxes paid by them, the cost of the relocation survey, incidental expenses, and other damages in the amount of 50,000 pesos, and to further pay them attorney's fees and litigation expenses in the amount of 10,000 pesos and the costs of suit. Meanwhile, the respondent court of appeals rendered judgment modifying the disposition of the court below by deleting the award for damages, attorney's fees, litigation expenses, and the costs, but not affirming the same in all its other aspects. As for the issues, the following issues are present in this case. First, on whether or not the private respondent spouses Celebrada and Abner Mangubat should be ordered to pay the petitioner DBP their loan obligation due under the mortgage contract executed between them and DBP. And last, on whether or not the petitioner should reimburse the respondent spouses the purchase price of the property and the amount of 11,980 pesos for taxes and expenses for the location survey. Continuing with the held disposition of the case, the court has read the judgment, whereas the appealed from is modified by deleting the award of 11,980 pesos as reimbursement for taxes and expenses for the location survey and ordering the respondent spouses Celebrada and Amner Mangubat to pay the Petitioner Development Bank of the Philippines the amount of 118,540 pesos, representing the total amount of the loan released to them with the interest of 15% per annum, plus charges and other expenses in accordance with their mortgage contract. With all other respects, the said judgment of the Respondent Court of Appeals is affirmed. To end the presentation, the dictum. Following the flow of this case, numerous references and claims, such as the case of Leather Manufacturers National Bank versus Merchants National Bank, claiming that whenever money is paid upon, the representation of the receiver that he has either a certain title in property transferred in consideration of the payment or a certain authority to receive the money paid, when in fact he has no such title or authority, then although there be no fraud or intentional misrepresentation on his part, yet there is no consideration for the payment. The money remains in equity and good conscience, the property of the payer, and may be recovered back by him. And as a general rule, is that if one buys the land of another, to which the latter is supposed to have a good title, and in consequence of facts unknown alike to both parties, he or she has no title at all, equity will cancel the transaction and cause the purchase money to be restored to the buyer, putting both parties in status quo. That's all for today. Thank you for listening. Have a wonderful day. Goodbye.